Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the appointment of two judges without advertisement. Having completed 10 years of service, the appointment is illegal. Whether termination will be legal or not. Supreme Court is now embroiled with this question. Appointment is definitely illegal, but they have completed 10 years service. What to do? This we are going to discuss. Please refer to the case law. Vivek Kaisth and another versus the state of Himachal Pradesh. On 20th, I think, the judgment was given by the Honorable Supreme Court in Civil Appeal number 6233 and 6234 by 2023 by Honorable Justice Sudhanshu Dhulia. He has authored the judgment along with Honorable Justice C.T. Ravikumar on 20th November. Now, let us know the details of the case. Of course, way back this relates to long year back incident because factual background, let us see the background. Right. In February 2013, so the Judicial Department, they have advertised to fill up the vacancies of 6 JMFCs or 6 civil judges. Every year they will be giving the advertisement. The expected vacancy is around 6 judges. Okay, fine. They have given the advertisement. Then people applied, about 1,000 people applied. Right. These 80 vacancies arise in the Himachal Pradesh. Actually, the Public Service Commission, they conducted the test. Right. Now, what happened is the vacancies were as far as 1/2/2013. Basing on the date, the vacancies are 8. But on 18/3/2013, just 2 months later, so 2 more vacancies are likely to arise. So therefore, they have already appointed 8. Plus, since if you are thinking of the future vacancies, they have appointed 2 other persons also, simply to say. And they have completed the, now 10 years service has been completed. 2013, by now 2023 means 10 years service they have completed. The problem is, they don't keep quiet. The others, will they keep quiet? Definitely, some others, they filed a petition or representation against them. Ultimately, Honorable High Court of Himachal Pradesh, they held that the appointment is illegal because the roster should be taken. The vacancies like SC, ST, BC, all these things, point should be taken, and then only the advertisement should be given. Yes, for that 8 vacancies are there again. But by the time of the so-called interviews and other things, they are expected the future vacancies, 2 vacancies, and they have taken these persons on temporary, and now they become permanent, and they wanted their services to be regularized on one side, these people filed petitions on some other side. Ultimately, the matter was quashed by the High Court. Then, agreed by the orders of the High Court, these people came to the Supreme Court. Now the problem is there. Very simple. The problem is like this. The appointment very clearly should not have taken place because you have to get people appointed only on the advertised vacancies. You can't expect the future vacancies. No doubt, suppose if that is the case, just within 1 month only, the 2 vacancies have come. But you have to reschedule the so-called procedure. You have to give another advertisement and then only appoint these 2 posts. So the appointment per se is illegal. Okay, accepted. But does it mean that these 2 people have to be dismissed or have to be removed from service. Here, the technical problem or the humanitarian problem, let us say, I have already had the experience of 10 years of service in the judicial department. It's not easy. Normally, a person who joins the service, he may have 30 or maximum 32 years of service. 10 years. So 1 by 3 is completed. He will be useful to the judicial service. They can't ignore his services. They don't take him away. Then what to do? So now, Honorable Supreme Court of India, using inherent powers under Article 142 of the Constitution of India, yes, they have retained these two judges. They will continue hereafter. Such mistakes should not be done. This is the crux of the judgment. Actually, it is a very dilemma. Because one side you are saying that the appointment is illegal. At the same time, you are not removing him. So, this is humanitarian view. So, it's not my self-dabba. In the year 2004, I have done the same thing. I was working as vigilance inspector in the AP electricity department. There was an allegation that a woman employee got employment through physically handicapped quota, even though she is not really physically handicapped. As vigilance man, I have to conduct an inquiry. I conducted the inquiry. No doubt, she is not having normally they will give some certificate. Physically handicapped persons, some organization is there, they have to give the certificate that if the physically handicapped percentage is more than 10, then only they will be called as physically crippled persons. Right. So she is not having that much of crippledness. Actually, she suffered from polio in the beginning, earlier days. She is from Karigira, some other area, I don't remember correctly. Right. The point is, definitely she got appointment. The appointment is illegal. But she has completed 14 years of service. Already she is an expert in the computers division, in the accounts division of SC office Ongole. At the time it was located near my house only. I think another part of third line. Then what to do? No doubt, illegal appointment. What is the purpose of sending her away? Already she has completed 14 years service. So I request the joint managing director, Sri Ranganathan Garu. He is still alive. So I told him the ground reality, this is the situation. Then he thought, what to do? Instead of losing her, okay, let us not give another, in future we'll be careful. Let us continue with her. And she retired. On a retirement function, I was, you may know, I was the chief guest. Right? So this is humanitarian condition. Of course, this is only my self-story, is not that important. But Supreme Court, using its powers under Article 142, they have continued the services of those two judges. Okay, with this I am concluding. Thank you very much.